Hello, friends and colleagues. This is Min Yao from Beijing Weiqi Law Firm, an IP law firm based in Beijing. I'm very glad to have this opportunity to meet you and share you with my IP practical experience. This time, I'm going to share with you how to adduce proof when claiming prior copyright in trademark opposition and invalidation cases. Firstly, I would like to briefly introduce my firm and myself. Beijing Weiqi Law Firm was formerly the legal department of Lindelof Partners. It became an independent law firm since 2008 to meet the legal business administration requirement in China. Lawyers at Beijing Weiqi Law Firm help Lindelof Partners deal with litigation cases. Both Lindelof Partners and Beijing Weiqi Law Firm are attached to Lindelof Group. Beijing Weiqi Law Firm is mainly engaged in litigation and contracts work, while Lindelof Partners in patent and trademark prosecution. I have until this year 14 years of experience in trademark prosecution and litigation. My experience in both prosecution and litigation enables me to consider various factors in dealing with trademark cases to achieve potentially the best result for clients. Just to name a few of the clients and cases I have represented: Royal Oak, one of the world's top watches in a trademark infringement and unfair competition case, and Atro, a well-known Italian fashion brand in a domain name dispute litigation, and Mr. Romero Brito, a famous pop artist in the US and around the world, in a series of trademark invalidation and administrative litigation cases. Get back to today's topic, how to adduce proof when claiming prior copyright according to Article 32 of China trademark law. The reason I want to talk about this issue is that a considerable amount of trademarks may be protected by Chinese copyright law when they meet the requirements of work, and the protection to work is not limited by the classification of goods. So claiming prior copyright in trademark opposition and invalidation cases has its own advantages. However, there is some misunderstanding about work and copyright in practice, and the creation of work does not require registration, which is different from patent and trademark. So, to prove the existence of copyright is much more complex than to prove registered trademark right or patent right. In this presentation, we are going to discuss the method and content of proof when claiming prior copyright. In the context of some practical cases, I hope this presentation will be of some help to you. When to claim prior copyright in accordance with China trademark law, usually the right holder needs to complete the proof of all these four requirements, and these four requirements shall be satisfied at the same time. Now let's look into the first requirement. The involved work constitutes the object of protection of copyright law. The work must be within the duration of copyright protection. In China, generally speaking, if the work is owned by a natural person, the period of protection is a lifetime plus 50 years after the author's death. If the work is owned by a company or an organization, it is 50 years since creation of the work. The work per se must meet two requirements: independent creation and minimal originality. Independent creation means the work is created by the author independently. It is not a copy of someone's work. Minimal originality means that the work should not be in public domain, not too simple, for example, not a common geometrical figure. Works with high originality, such as Peppa Pig, Kung Fu Panda, and Minions, are undoubtedly works protected by Chinese copyright law. There is generally no dispute that such artistic images can be protected by China copyright law. The trial guidelines of Beijing High People's Court pointed out that those lacking originality should not be recognized as works. Simple common patterns, letters, are generally not recognized as works. In practice, it is often simple patterns that are controversial in terms of whether they meet minimal originality. It is possible that different judgment subjects to give different conclusions. The trademarks in the first column are the trademarks in dispute. The works shown on the second column are the works that the right holders claimed prior copyright. It can be seen from these cases that for the same work, administrative organs and different courts may reach completely different conclusions on whether the science meets minimal originality. Moreover, it is difficult to define which organ or which court has stricter judgment standards. It is impossible to exclude the subjective factor when to judge whether a work meets minimal originality. So for the right holder, even if it is a simple patent, claiming copyright is still recommended. To improve possibility of protection, the right holder should clarify the original expression of the work as much as possible and explain the reasons why the work meets the minimal originality requirement. In addition, it should be noted that the level of originality and the scope of protection is closely related. The higher the originality of the work is, the wider the scope of protection. Let's look at some examples. Doraemon is a work of high originality. Its scope of protection is also wider, and this trademark in dispute was considered substantially similar to the work Doraemon in the trademark opposition case. And for these devices, they are simple in design, thus their scope of protection is also narrower, usually limited to the situation in which the trademark in dispute is exactly the same or basically the same as the copyrighted work. Now let's look into the second requirement. The party concerned is the copyright owner or interested party of the work involved. This is a very important requirement, and proof of copyright ownership is easily misunderstood in practice. Some applicants of the opposition and validation cases believe that they are the first to use and apply for registration for the trademark, so of course they enjoy copyright over the trademarks. In fact, the nature of copyright is different from that of trademark rights, and the trademark owner of a science does not, of course, own the copyright to that science. I'm going to clarify this issue through 4 parts. Part 1, who the copyright of the work belongs to. Part 2, proof of copyright ownership. Part 3, what if the right holder cannot provide work creation proof? Proof of copyright interested party. Part 4, our suggestion. Let's look at part 1, who the copyright of the work belongs to. Generally speaking, there are 2 ways to acquire copyright, namely original acquisition and derivative acquisition. For these 5 categories of works, the right holders enjoy copyright due to creation of the work or due to the provisions of the commission agreement. Such copyright is original rights. In addition to the above-mentioned original rights, there are also copyright-related rights obtained through transfer, inheritance, or licensing. The ownership of copyright can be basically summarized as the copyright of a work belongs to the author who created and completed the work if it is not otherwise stipulated by law or agreement. Part 2, proof of copyright ownership. And in the part 1, we have clarified copyright ownership. Now let's look at part 2, how to prove copyright ownership. When to prove copyright ownership, it is mainly to prove that the right holder is the author who created and completed the work, or that he enjoys and acquires the rights based on the provisions of the agreement or law. For author who created and completed the work, such materials can be submitted to prove creation of the work. Work manuscript or an original work with author's signature, publications of the work showing the author's name, copyright registration certificate with author's name. If the copyright is obtained through agreement, the relevant agreement can be submitted. Now let's think about a question. What if the right holder cannot provide work creation proof? It is still possible to claim copyright. The right holder could prove he is the copyright interested party. According to my experience, a situation often occurs in practice is that due to a long period of time and a large number of cases, the right holder could not provide work creation proof. What they can provide generally includes prior trademark publication and registration data at home and abroad. Earlier, newspapers and magazines of advertisements, online media materials, sales materials, exhibition materials, which are all trademark registration and use materials, and the later copyright registration certificate, which is obtained when to deal with the trademark opposition or invalidation. In previous years, in the case of the right holder, being able to provide the trademark registration and use materials, as well as a later copyright registration certificate. Without contrary evidence, the court would generally determine that the right holder enjoys the prior copyright to the work involved. However, the registration and trademark use materials often only reflects the registration and use of trademarks, not the creation of work. And moreover, the ownership of trademark right is not necessarily the same as the copyright. Therefore, only trademark registration and use materials are not enough to prove that the trademark owner also enjoys copyright to the trademark. In recent years, the court has shown a more rigorous attitude in determining the copyright ownership under such situation, considering that there are indeed difficulties for the right holder to produce work creation proof in practice. The Supreme People's Court made judicial interpretation to solve the problem. Let's look at Article 19 of the Supreme People's Court's judicial interpretation. The third paragraph. The trademark publication registration certificate can be used as preliminary evidence to determine that the trademark applicant is an interested party who has the right to claim the copyright of the trademark sign. In two cases, we have represented the Court of Second Instance, admitted the prior trademark registration and prior publicity trademark materials can prove that the copyright of the work involved in the case is a prior right generated before the filing date of the trademark in dispute, and determined that without contrary evidence, the plaintiff is the interested party of the work involved and the plaintiff could claim prior copyright for the work involved. Now let's look at the final part of the requirement 2, part 4, our suggestion. To prove prior copyright certificate is very convenient. We suggest the right holder apply for copyright registration when the work is completed or the copyright is obtained. When trademark imitation or squatting has occurred, a later copyright certification also helps, and the right holder is recommended filing copyright registration. Now let's look into the third requirement. Before the application date of the trademark in dispute, the applicant of the trademark in dispute may have access to the work involved. This requires the right holder to prove there is a possibility for the adversary party to have access to the work involved. In practice, possibility of access is generally proved by providing prior publicity materials of the work. That is, if the right holder can prove that before the application date of the trademark in dispute, the work has been published, such as in newspapers or magazines, online media exhibitions, it is presumed that the applicant of the trademark in dispute may have access to the work involved. At this point, we can see that publicity materials can serve two purposes. The first is to prove copyright ownership and copyright interested relationship. The second is to prove the possibility of access to the work by the applicant of the trademark in dispute. Here is, we also need to pay attention to these points and to prove possibility of access. Scope of publicity. Is coincidence possible if the trademark in dispute is substantially similar to the copyrighted work? For example, in one case we represented, the third party claimed that the magazines submitted by the plaintiff were all publications in Japan. The third party had no access to them. But in the end, the court recognized the third party may have access to the news reports published on the Internet. From this perspective, publicity evidence on the Internet is important to successfully prove possibility of success. And for a work which is high in originality, and when the work in dispute is exactly the same, emphasis can be made that identity is hardly a pure coincidence, which may also have a positive effect on the examiner and judge's discretion. For a work which is low in originality, it cannot be completely ruled out that the trademark in dispute may be independently created and is substantially similar to the work of the prior right holder out of coincidence. However, at this time, if sufficient prior publicity evidence has been provided, and there is also possibility of access, if the applicant of the trademark in dispute claims that its trademark is created independently, the applicant of the trademark in dispute shall prove for his claim. Now we are going to talk about the last requirement. The sign of the trademark in dispute is substantially similar to the work involved. This requirement is mainly about the comparison between the trademark in question and the right holder's work. The trademark in question and the work will be put together and compared entirely and in details, including the content, layout, structure, color, and other factors to determine whether they are substantially similar. The first thing to be noted is that the judgment standards of substantial similarity of the works are not the same as similarity of two trademarks. They have different comparison rules. For example, popularity of a trademark shall affect similarity determination between trademarks, while popularity of the work is not a factor to be taken into account in comparison to the trademark and the work. However, popularity of a prior work indeed affects the determination of possibility of access. Let's look at some examples. This trademark in dispute contains a part which is a creative part of Doraemon's face. Since the trademark in dispute imitates the creative part of the copyrighted work, the trademark in dispute was determined substantially similar to the work in the trademark opposition case. And this is the trademark in dispute. These two characters are different in gesture and accessories, hat, brush, and bow tie from the copyrighted work, but they imitated the creative part, the body and face of the copyrighted work. The trademark in dispute was determined substantially similar to the work in the trademark opposition case. This trademark in dispute contains a part which is exactly the same as the finding monster eyes. The trademark in dispute was determined substantially similar to the work in the trademark invalidation and the following litigation case. This trademark in dispute and the work both contain a boot device. The trademark in dispute was determined substantially similar to the work in the trademark invalidation case by the TRAB. The first instance and the second instance court held the same opinion. However, the Supreme Court held the boot device and the work is simple. Thus, its protection scope should be narrower and determined the trademark in dispute is not substantially similar to the work. We have discussed all the 4 requirements to prove a prior copyright in accordance with Article 32 of China trademark law. Now it's time to make a summary for today's presentation. Prior copyright is a useful tool in practice to fight against trademark imitation and squatting. To facilitate the exercise of copyright, the right holder can do these things, including filing copyright registration when the work is completed, signing a contract with clear provisions of ownership of rights, and paying attention to collect and save evidence about the creation and publicity of the work. Thank you for your time. If you have any question about this presentation or any question about IP protection in China, you're welcome to contact me or my firm. Goodbye. See you next time.